Okay, good morning, everyone. Uh, Good morning, everyone, and welcome to this to the launch of the latest IRR report by Martin van Staden, Civil Liberties in South Africa. And I think as we sit here, the thing that I can't help thinking about is what has been the news cycle in the last 24 hours. A group of presidential security officers uh, assaulted a road user. It was captured on camera, and I think this goes to the heart of what I think a lot of us in South Africa are questioning about the country. What does a constitutional democracy? What is a country supposedly founded on values of freedom, democracy, civil liberties, justice? What does it mean when a motorist can be assaulted like that? Not arrested, not taken into custody, but beaten up and left at the side of the road. Now, there's quite a bit of polling evidence over the last couple of years that shows that South Africans are becoming very cynical about the state of our politics and about the state of our governance. Uh, Corruption, failure to raise living standards, the sense that some people are simply beyond the reach of the law. All of these are inflicting damage on the way we see our democracy. But is the picture uniformly bad? Is it uniformly good? And to discuss that, our former colleague and longtime friend of the IRR, now with the Free Market Foundation, Martin van Staden, will be taking us through his latest publication. And with that, Martin, over to you.
Thank you, Terence. I'm still with the IRR in some capacity, so I like to think of myself as a former and a current colleague. And of course, the IRR is South Africa's foremost classically liberal organization, and certainly its oldest. So it's a very appropriate place to be talking about civil liberties in a time like this. I want to thank everyone for attending this event. It's an honor for me, really, to address this audience on a topic that I think doesn't get its deserved attention. The words liberty or death, or even death is a preferable alternative to communism or to fascism, might be quite jarring to a modern South African audience. And in some respects, it might even seem comedic. But in the context that these words were uttered originally, they were quite serious and sincere. Liberty or freedom, really the fundamental right to do as you please without having to seek some regulator or politician's permission, is quite precious. But as we all know, it is limited today. And some like myself might say that we are entering, if we have not already entered it, a dangerous period where liberty is being taken entirely for granted. It is almost just a background thing that people don't really pay too much explicit and conscious attention to. Other things, aside from liberty, pique our interest today. And I'm not sure that we as a society are fully cognizant of the fact that if we lose liberty, these other things that we value so highly would also become seriously threatened. And as Terence mentioned, it's timely to discuss civil liberty this week. We've all, I think, seen the video of the deputy president's presidential protection detail beating up what I would say are compliant motorists. They've definitely been neutralized as far as being a threat to anyone is concerned, and they're being simply beat on. Now, as is mentioned throughout the report that we're discussing, guaranteeing liberty is, in fact, the highest duty of the institution we know as government or the state. But in South Africa and indeed elsewhere, governments have lost sight of this. Police beating up civilians is not indicative of a government that believes its calling is to safeguard freedom under law, but of a government that is itself, I would say, lawless and regards itself really as a ruler, almost a king, rather than a provider of a service. Now, the title of this report is Civil Liberty in South Africa, Freedom Under Law 3 Decades After Apartheid. It was inspired by a book from 1958 written by Edgar Harry Brooks and J.B. Macaulay called Civil Liberty in South Africa. And this book was, in fact, commissioned by the Institute of Race Relations all the way back then. And this book analyzed the state of civil liberty in the country in the decade since the National Party came to power in 1948. Now, this was a timely work which explained, really with the standards of the rule of law as the author's yardstick, how freedom had been lost in the name of racial segregation. Now, it seems rare for works like that of Brooks and Macaulay to appear today, and one is left wondering why. I might hazard a guess that many observers and commentators take false comfort in the Constitution, believing that the mere presence of a constitutionally guaranteed set of rights means that we can shift our focus away from civil liberty to other things. Now, we'll get to the Constitution a bit later on, but suffice it to say, no matter how strong the supposed legal protections for freedom are, once society as a whole takes its eye off the prize of liberty, the powerful enemies of freedom spring into action almost automatically and begin chipping away at the existing state of liberty until very little is left. But it is true, and I don't want to be entirely pessimistic, it is true that the state of freedom under law in South Africa today has improved since 1994 and certainly since 1958 by leaps and bounds, really. As we sit here today, South Africa is a free society, and I think in many respects it might be freer than many Western states. But this is not a cosmic guarantee. Every year, a new policy or law waters down civil liberty in the name of some other ostensible social good, like social equality or social cohesion, or the many other misapprehensions of the so-called public interest, which make us really imperceptibly less free every time a law or policy like that is adopted. And these interferences, although imperceptible at the moment they are adopted, they do add up over time. Civil liberty is therefore quite precarious and can be lost if it's not jealously guarded by a vigilant civil society, an independent judiciary, and ideally, although this might be a pipe dream, a political establishment that regards freedom, that in fact values freedom and supports the idea of freedom, rather than treating it with indifference, suspicion, or even, as I think we might be experiencing sometimes in South Africa, with contempt. And I think South Africa's political establishment has shown itself to regard civil liberty as an annoyance at the very best and an obstacle to be overcome at worst. This report details some of the ways that government has gone about undoing civil liberty. It also talks about how the Constitution guarantees civil liberty and how in the future we can better protect civil liberty. But before we get to that, we must briefly contextualize civil liberty and understand why, what it refers to, in fact, and why it is important. So, up until relatively recently in the history of human civilization, the state and its institutional predecessors, here you might think of a tribal chief or a king, and so forth, even in some respects, maybe even just the head of a household, were not subject to the limitations of law. The law has always existed, of course, since humans first drew breath. But the state was not regarded as a legal subject like ordinary people and businesses and organizations are. The state was legally allowed to ride roughshod over the interests of those who lived within its jurisdiction. It was not subject to legal limitation. But this did start changing around the time of the Enlightenment, I would say, 400 or so years ago, when the fundamental worth and agency and capacity of the ordinary individual became recognized in law, alongside the concept that we know today as constitutionalism. And constitutionalism really, at the end of the day, means that the state too is subject to limits imposed by law. It does not exist above the law. It is not the originator of law, but there is a set of law that simply binds the state. There is no more legal sovereignty that resides in the state. So the real break with the past, at least according to my reading of history, as far as constitutionalism and human freedom are concerned, came in the form of the American and later the French revolutions in the late 18th century, when fundamental legal instruments, so-called supreme constitutions, were adopted that entrenched the at least formally entrenched the rights of the general population, from the lowliest peasant, poor person, all the way up to the wealthiest members of society. All had, in law at least, the very same rights. And this means that civil liberty and the law are therefore quite related concepts, I would say inextricably so. Whereas liberty, just liberty, can be defined as the freedom of the individual to do as they please with themselves and their property, civil liberty, on the other hand, can be thought of, according to Brooks and Macaulay, as, quote, those natural rights essential to the free development of personality under the guarantee of law. Liberty, as recognized and protected by law within the context of a political dispensation, is therefore civil liberty. And a nice kind of analogy that I've often thought of is, imagine you are someone who lives in the middle of the Congo rainforest. The central Congolese government has no capacity. The local warlord probably also doesn't care too much about what people get onto on a day-by-day basis. You have liberty, and you have a lot of it. You can basically do what you want, when you want, and no one is going to interfere with you. You have de facto freedom, almost absolute freedom. You are free, you have liberty. But still, the Congolese state has laws that infringe on liberty. The rebel warlord does not regard himself as limited by law. He still has this idea that he can ride roughshod over the interests of everyone around him without a care in the world. So there is no civil liberty there. Civil liberty is when the law, in fact, guarantees that freedom that you have and says that no one may interfere with that freedom of yours. And the law will come to your protection if, in fact, someone does. So there is that difference between the de facto liberty that can exist anywhere at any time, really, regardless of what the law says or what the government is doing, and civil liberty, which is both de jure, legal, and de facto. So where there is civil liberty, the people themselves decide what is important to them and act in accordance with that decision. And the law merely facilitates their pursuit of their own interests. The government, as I alluded to earlier, under such a dispensation, is a service provider. It is, if you want to see it hierarchically, it exists below the people. It provides a service. It is not a direction giver. The opposite of civil liberty, then, is social engineering, like under apartheid, and in many respects like today. And under such circumstances, one does experience a large degree of freedom, of course. But ultimately, the government sees its role as providing so-called leadership to society and implementing a substantive agenda with which everyone in society must ultimately fall in line with. That is social engineering. That is not civil liberty. In the last while, we have seen this around the world, really, in the economic realm in particular. Governments say that they want to increase social equality and social mobility and all these nice things by engaging in the so-called better management of the economy. Now, in legal circles, this has been very crudely justified by drawing an ostensible, a false distinction between personal or basic or fundamental freedoms and economic liberty. And this is really how the government has gotten its foot in the door. Freedom of expression, privacy, the right to dignity, these are apparently basic freedoms that must be protected and protected at all costs. So even in South Africa, when government threatens these freedoms, civil society rightly lights up and comes to the defense of these important values. But property rights, freedom of contract, and even consumer choice, the right to smoke in your own house, the right to sit at a bar and drink yourself stupid for many hours, these are not regarded as basic freedoms. Often only big tobacco, big agriculture, and big business stands up for these freedoms. Definitely not as because they support civil liberty in principle, but because their own interests are being threatened, and oftentimes they are on the out end of violating freedom. But it's unfortunate that when it comes to economic liberty, it is kind of left only to that specific sector of society to come to its defense, even though it's so crucially fundamental to the prosperity of society as a whole. And this silence that you kind of often see from ordinary members of civil society is really informed by this false distinction between personal and economic liberty. So why is it a false distinction? Well, you can see that with any example. So a media house, a newspaper reporting on corruption is not simply freedom of the press or freedom of expression. That is a private business that is owned by people, and that's private property rights. The printing presses for the newspaper is private property. The studio is owned by a news company is private property. In the same way, a smoker being able to smoke in their own house or in their own car is not just consumer choice. It is also the right to dignity. There is that basic right, and it overlaps entirely with a so-called economic liberty. And of course, very contentiously in South Africa, a farmer being able to subdivide their land as they wish to sell smaller plots at more affordable rates to others at the marketplace is not just property rights, a preserve of the privileged elite. It is privacy. It is that farmer's right to privacy. He has a right in his own domain, on his own property, to do as he pleases with his property without busybody interference from the Department of Agriculture. So civil liberty is in fact a holistic concept that guarantees under law to ordinary people and their businesses the maximum autonomy to do as they see fit without political interference. So what is the situation in South Africa in particular? You'll need to look at the report where several instances of government intrusions into civil liberty, and I might add also government protections of civil liberty. It's not all bad, but I focus in this launch event on the bad aspects. But because we have limited time today, I will only mention a few of these things that you'll find in the report. I think the first and most unnoticed threat to civil liberty, and this is something that happens around the world, but also here, is the wide discretionary powers and even lawmaking powers that Parliament gives to ministers and to regulators in terms of legislation. The theoretical rule is that only Parliament may limit the rights of the people in clearly stated legal language. But in practice, the practice has been to increasingly allow executive officials and regulators to limit civil liberty at their discretion. So here one might think of the powers of regulators, even in the mining industry, for instance, to simply close down a shaft if they deem it to be in the public interest in those circumstances. Or the Minister of Trade and Industry, who has recently extended a ban on scrap metal, to summarily really ban import and export of certain goods. This is one guy making this decision and signing a piece of paper, and with that goes millions of rands in economic goods that have to do with your economic liberty. So unconstrained discretion, where the law does not limit how this discretion is to be exercised, is really a significant threat to freedom under law. But more particularly, South Africa is facing two existential, in my view, threats to both freedom of expression and to private property rights. The first is the hate speech bill, which is currently with the National Council of Provinces and has been received with much fanfare in the discourse and much opposition, thank goodness. Now, I'm not going to go into too much detail, but what this law does, it criminalizes so-called hate speech, which is defined quite broadly, but far better than the previous version of this bill. And South Africa already had hate speech declared a civil wrong in terms of the Equality Act. And we've used the, I think improperly, but we've already used the doctrine of crimen injuria, which is a criminal law doctrine, to punish hate speech. But still we have this bill, which kind of alludes to the fact that government wants to signal to society that it's doing something, when in fact this threat to freedom of expression is simply not necessary, since the legal tools are already there. One of the big issues of the bill is that it potentially interferes with the discourse, the rapidly changing discourse, in fact, on so-called gender and gender identity and gender expression. These things that a decade ago we thought of very differently than we do today, and it's a rapidly evolving idea. Because the bill allows, in the course of this discourse, you to do any social or economic detriment to someone, and detriment, I think, as we can all agree, is a very low threshold. And if you ask me, as a legally trained individual, there is no such concept in law, detriment. We have a very well recognized concept of damage in law. We have a very clear concept of infringement of rights in law. But detriment, no, that is something that just happens in a free society, in a perfectly legitimate discourse. We cause detriment to each other simply by living and acting and breathing. So it's acceptable, and the government and the law should not interfere with that. The only thing really that must matter legally is whether we are infringing on one another's civil liberty or damaging one another's property. Now, there is a popular argument, unfortunately, even from opponents of the bill, that don't worry, the courts will protect us. We have this bad law, it's terrible, but the courts will protect us, we have nothing to worry about. That is cold comfort, unfortunately. Hate speech is a very politicized concept, and the courts in South Africa, unfortunately, I would say, have shown themselves to not be immune to this politicization of this legal doctrine, where we've seen, in my view, a very unequal application of this concept. And I have sympathy for the courts, because I think if they were to apply hate speech law consistently, we might see the government, in fact, taking really, really draconian and authoritarian steps against the courts, in the way that Franklin Delano Roosevelt did in the United States several decades ago, when the courts really go against the government's agenda. So I have sympathy for the courts, but that is more reason for us to not just think the courts will just protect us from the abusive application of the hate speech bill. We must protect freedom of expression at the gate, and that means we must ensure that this law does not see the light of day. I move now to the expropriation bill. I think everyone here is also quite familiar with that and the threats that it represents to our economic prosperity. I'll mention just a few highlights from the expropriation bill. The biggest thing is that ultimately compensation for expropriation will now become optional. It doesn't take away compensation, but it gives government that option to say, listen, in fact, we are going to take this property without compensation. There is no limitation on the amount of circumstances under which that may happen. There is a nominal reference to it must be for land reform purposes. And these are kind of 5 circumstances as examples, but not as a closed list, as examples of when the government might want to do this. But none of that really provides a substantive legal limitation on the government's power to expropriate without compensation. So, with a sleight of hand, the so called expropriation bill does away with expropriation. Because to any lawyers watching, you'll know that expropriation as a concept is inherently tied with compensation. From the very moment that Hugo de Groot, hundreds of years ago, first conceptualized the idea of imminent domain of expropriation, the very next sentence, he spoke about compensation that must be paid to the injured owner. You cannot divorce expropriation and compensation and keep expropriation. What this bill does is it opens the door to arbitrary government confiscation of property, and that is unheard of in liberal democracies and in constitutional democracies, in fact. Another bad aspect of the bill is that when the government decides to expropriate your property with or without compensation, you must hand it over. Yes, of course, you're allowed to challenge that in court. You can challenge the amount of compensation, you can challenge the process, you can challenge the reason for the compensation. All of these things are in the bill. You're allowed to go to court, but you have to give your property to the government first. And if you win that court case 2, 3, 4 years later, yes, then you may get your full compensation, or you may even get your property back. But the fact is, this is another trick that really goes unnoticed, and that people don't realize is a significant threat to everyone except the most wealthy South Africans, because the very 0.01% of South Africans who are able to run a legal case, even though their income earning property has been taken from them, is a very small group. Other South Africans, even wealthy South Africans, but definitely middle class and poor South Africans, once they have to hand over, say, a shop or a business, it's not just agricultural land, remember, this applies to any fixed property. Once they have to hand that over, their income dries up. They're not going to be able to fight a court case unless they have legal aid, which for a case that really relates to property like this is probably not going to be very easily obtainable. So this is a very draconian kind of trick that the bill performs. You have to hand over your property first, and then you get to challenge it. We are kind of running low on time, so I'm going to speed through the next one. So we were all very unfortunate to experience South Africa's COVID-19 lockdown. And I think with this, we really saw what happens when this government is certain about the righteousness of its cause. There was a huge elimination of civil liberty in the so-called public interest, and many people simply fell in with that and said, oh yes, it's for public health, it's for a good intention, therefore this is fine. Even though I would argue the Constitution is unequivocal about that not having been fine, and that the process government followed was in fact very, very unconstitutional. So we saw things like bans on tobacco and alcohol sales. This cost billions, not only to the companies and the whole value chain, retailers, small retailers who sell these products, but also cost the government billions in tax revenue that it lost out on. There were also bans on the sale of hot chicken and open-toed flip-flops, because why not? The government felt righteous about its cause, and then we saw this ridiculous interference with a very elementary liberty of people to buy open-toed flip-flops. Freedom of movement, of course, was totally curbed for several weeks. And the police brutality, I think, especially in the first few weeks where the police and the military felt, wow, we have now really been empowered. It was insane. There were dozens of deaths as a result of people apparently flouting these now sacred lockdown rules. We had the police chasing people off the beach where they would probably be safest from the virus, back into crowded pavilions and sidewalks where apparently you have to go because some minister said that's where you have to be. And maybe most, to add insult to injury, the government, or the Electoral Commission at least, tried to have a whole South African election postponed due to COVID-19. So yes, even democracy itself could suffer when civil liberty is in the target sights of a malicious government. Now, these were some of the threats to civil liberty, but now let's ask ourselves, how is civil liberty protected? Most of you are familiar with the Bill of Rights and how it works. There are various constitutional rights listed there, and we may call upon them when we feel that they have been violated. And this is common knowledge. But my interest in the report is in one of those provisions in particular, Section 36. Now, Section 36 is the limitations provision and is sometimes known as the weasel clause. And it's regarded by most people as a provision that allows government to simply nullify kind of the constitutional rights that appear in the Bill of Rights. And it provides government a roadmap for how to do that. Now, I argue that this is a fundamentally incorrect conception of Section 36, and that society must use Section 36 rather as a protector of liberty, rather as a violator of it. All around the world, governments do limit civil liberty. There is no exception anywhere to this. To say that Section 36 then allows or enables government to do so is quite silly in my view, because government has this entitlement to limit civil liberty, really as an inherent feature of its very nature. So what Section 36 does instead is that it puts a limit upon the government's power to limit rights. It is not a limit upon the constitutional rights of South Africans, but a limit on government. Now, how can I say this? Well, because Section 36 is clearly concerned with justification. The provision is built around the notion that if the government is to limit civil liberties, it must justify that limitation to an impartial tribunal, being a court of law. Usually, this is not necessary around the world or throughout history. The government can simply limit rights, and the courts will determine whether that has been done legally, following certain legal steps. But in South Africa, Section 36, we incorporated an old, I would say, American legal and constitutional institution, which is not even applicable in America anymore. And we might call this the Lochner Doctrine, after a famous American case, where the law requires the government to fully explain and convince the courts of the justifiability of its limitation on constitutional rights. It is a significant limit on the power of government. But our courts have not always respected this nature of Section 36 and have often, and I would say too often, approached it very haphazardly. So now I discuss how we can better protect civil liberty in South Africa. And I will, as I do so, I will mention how the courts have kind of misapplied Section 36. And I'm going to try and do this as quickly as I can. So firstly, as far as Section 36 is, there needs to be a higher standard. The courts have to change their fundamental conception of how this institution plays out in South African law and in public policy. Firstly, the courts should always insist that government should have provided a Section 36 justification for any limitation on rights. The court cannot allow a case to come before it where government has not justified the limitation at all. Then the court must simply find the limitation unconstitutional. The government must not at the case itself, at the hearing, provide its justification, because now the limitation has already been applied. Section 36 requires the government to apply the formula in that provision before it limits constitutional rights, not ex post facto with hindsight. So the courts must be very strict on this. To say that, listen, was there a justification before this hearing began? No. So unconstitutional, the limitation is thrown out of the is declared unconstitutional. The justification must also be comprehensive, and this is a mistake that the courts and the government has made repeatedly. So Section 36 is a formula. It contains certain principles by which you measure the justifiability of a limitation. And our courts and the government kind of skip over some of these principles when they feel that it's not really convenient for them to apply it. And the most important one is Section 36 1E, which says that if there is a less restrictive means available to the government to achieve what it seeks to achieve without doing what it has done in as part of the limitation of the right, then that less restrictive means must be preferred. So let's go back to the hate speech bill. The hate speech bill criminalizes hate speech. It can send you to jail for up to 8 years. You can go to prison for up to 8 years for something you said or expressed. The courts must now ask, and the government, in fact, must prove before it even adopts this law, that there is no less restrictive means to achieve what they seek to achieve. Now, already that the hate speech bill has failed because we have less restrictive means. The Equality Act, crimen injuria, even, which is a developed doctrine of law that has jurisprudence associated with it. So there are less restrictive means. And as a result, by applying this principle, the hate speech bill must be declared unconstitutional. But I can guarantee you, and you'll see in the cases that come up once the bill becomes law and it's challenged, less restrictive means is going to be skipped. The courts are going to skip it, and the government is going to skip it, and that's not on because you kind of make a mockery of a supreme constitution if you pick and choose which of its words you are going to apply in the circumstances. The courts must also start insisting on Section 36 or applying Section 36, even if the parties before it do not invoke it. So during the COVID-19 lockdown, a bunch of our colleagues, in fact, from the Free Market Foundation and at the time from the IRR, got together and challenged certain lockdown restrictions. It was the Issal matter after Dwayne Issal, where they went to court and they argued on the basis of rationality. They said these lockdown restrictions are irrational. That's a fine argument. That's a good argument, and it's good that they made that argument. But it was also, of course, a matter of civil liberties, because they also implicitly said that constitutional rights were being limited. But the court did not apply Section 36. You can read that whole judgment, and Section 36 is never applied. And this must not be allowed. The courts they have sworn to uphold and protect the Constitution, and Section 36 must always be applied. It must not be a discretionary application. It must be a compulsory application. The courts must also insist on strict necessity. There's this idea that if the limitation is necessary to achieve the end, the good constitutional end that the government is pursuing, it would be allowed. But it must be strictly necessary, not reasonably necessary or even expedient. The court must ask itself when analyzing a limitation of civil liberty, was this really the only way that the government could achieve its ends, that its good constitutional ends, or was it only expedient? So that question must be asked, and if it's not strictly necessary, it should be unconstitutional. Then also the courts must always approach a civil liberty matter in favorem libertatis, which is an old common law principle which says the courts must approach the issue in favor of the liberty of the subject, not in favor of the agenda of the government. And finally, I think worth mentioning here is that the courts must have regard to the substance of a limitation, not its form. So again, from the lockdown, there was a case where FITA, the Independent Tobacco Association, challenged the ban on tobacco, I believe it was. And what happened there was the court in the judgment acknowledged that the tobacco ban did not achieve the purpose that government set out to achieve. In fact, there was more smoking during the tobacco ban because people got loosey cigarettes for cheaper than they would otherwise. And these cigarettes were more harmful. They were unregulated black market cigarettes. So the ban resulted in more smoking and more dangerous smoking. And the court said, well, this is fine because in theory, the ban kind of can achieve what the government wanted to achieve, which is less smoking and kind of better immune systems to deal with the virus. So the court, in fact, only had regard to the form of the limitation, not its substance. It did not care about what actually happened in fact. It only cared about what could theoretically happen under ideal circumstances. And that must not be the case. So the report also details certain parliamentary interventions aside from the courts, certain laws that Parliament could adopt to better protect civil liberty. One of these is a Promotion of the Rule of Law Act, for instance, which, among other things, must introduce general criteria that constrain any discretionary power found anywhere in any legislation. according to certain principles that this new law must spell out. How must the discretion be exercised? What must be taken into account when discretion is exercised? Then also another law, an advancement of human rights and freedoms act. This term is taken from the foundational provisions of the Constitution. A few things that Parliament could put in such a law is that it must require, as I've now explained, it must require explicitly that government provide a Section 36 justification for any limitation of civil liberty whenever it acts, whenever it adopts a policy, whenever it proposes a new law. There must be a Section 36 justification. There must also be a rule that says no provision may be interpreted as implicitly limiting someone's freedom. If the intention is really to limit a constitutional right, it must say so explicitly. The provision in the law or the policy or the regulation must say, South African Section 16(1) right to freedom of expression is hereby limited. And that must be explicit. It must not be implicit. There must Parliament can adopt a Protection of Property Act, because we all know South Africa's government has been very lax in its protection of private property, and this would be a good change of pace. Then also non-racialism, a fundamental aspect really of civil liberty, as South Africans would know better than anyone else, how race could be used as a pretext to take away all sorts of freedoms from ordinary people. Parliament should, I recommend in the report, adopt a law that prohibits any organ of state or any functionary, any government official from classifying or categorizing any person with respect to their race, ethnicity, or skin color. And this includes any direct or indirect or express or implicit requirements or even encouragement for them to self-classify. Effectively outside of the census. I think in the census we may ask people how do they self-identify racially, but outside of that, no representative of government should be allowed to inquire into the racial identity of any person. And even during the census, the numbers of people belonging to a race must be delinked from the individual identity of a person, of a South African. There must be no link between you ticking black, white, colored, or other, and your name and your ID number. That must be immediately delinked. And then finally, Parliament could adopt and should adopt legislation that really brings about political decentralization. It's been widely recognized that the decentralization of political authority from the center to more dispersed and diffused locales of government power is an important instrument to protect the freedom of ordinary people. And I think we've all seen many calls in South Africa over recent months for decentralization. And then just the final thing that government could do to improve civil liberty is you have to inculcate a respect for freedom amongst ordinary civil servants, the people who interface with government, with the public, the police, of course. So there should be somewhat of an effort to talk to the police and talk to civil servants and say, listen, the ultimate purpose of government is to protect people's freedom. You're not ruling over this population. South Africans aren't your toys. They're not an annoyance to be tolerated. You serve them. You serve their freedom. And this does not exist currently in our civil service. And this is probably the hardest thing that I think should be done, but I think it's probably the most necessary thing. So let me conclude with these brief remarks. I may have seemed a little bit despondent or pessimistic in this report, but that's not the case. South Africa has a huge leg up over other African countries, certainly, and even over many European states and Asian states, etc. And that is, we have a very vigilant and strong civil society that has really taken the bull by the horns and said, listen, we're not going to wait for the courts or for government to get its act together. We are, in fact, going to start protecting our communities, our families, our businesses, and government can catch up if it wants to. We are taking the initiative, and that is great news for civil liberty in South Africa, and it makes it far easier for us to protect civil liberty, and it kind of doesn't make it an imperative for the government or for the courts to implement the recommendations I've made today, because we are protecting civil liberty. We are protecting it de facto. We are in practice setting up those structures in our communities that ensure that people can live free and prosperous lives. This is not happening widely enough yet. There are many communities in South Africa who are not organizing themselves yet. And I think it's high time that they should do that and engage in some much needed state proofing against malicious incursions into their civil liberty. I have gone over time. I apologize for that, but I am available for a few questions right now. But you can also feel free to pop me an email. I am very available. I'm very eager to answer any questions or queries or statements that you might have. Thank you again for joining us and making time out of your busy schedules.
Thank you, Martin. Before we go, I see there's really a question in the chat, but before we go, I'd just like to throw out a few observations from my own from what I heard. I think the first thing is that liberty is not license, and I think that's a point that we often miss or is missed in the debate. That it's everything, including the most pathological or nothing, or a sort of nanny state. And I think that the organization of a free society, first of all, it assumes a society, not just atomized individuals, but some sort of consensus about how liberty is to be exercised. That brings me to the next point, and that is that freedom is a choice. Liberty is a choice, and as you say, it often comes across as a sort of background noise that we assume as a given. But I think that what we've learned in South Africa is that it's not actually an inherently natural one. And even though we have a line in our national anthem about living and striving for freedom, during the COVID lockdown, there seemed to be a celebration of the heavy-handed use of government power. Now, let me say that I was not entirely unsympathetic to the idea of lockdown, at least not initially. But I thought there was a difference between saying that this is an emergency pragmatic measure and having hashtags, thank you, Cyril, for locking us up. I think also what that showed was that there is a strain of pathology that runs through our governance, and I think that some in government, not all, demonstrated that they were very, very happy living with a controlled society. The head of the army told his troops not to let anyone disrespect them. Now, using your military to police your civilian population is a huge step. And I'm old enough to remember the 1980s, where that was one of the great demands: troops out of the townships. We had soldiers beating people to death, and interestingly enough, that Collins Causer never came anywhere close to being the type of celebrity that George Floyd, half a world away, became in South Africa. No. In fact, I actually put that question to a group of matric students a little while ago. Who can tell me who George Floyd was? Who can tell me who Collins Causer was? A lot more virtually no one could tell me who the second was. I think that something else to take away from this is that liberties either exist on the individual level or they don't exist at all. And I think sometimes there's a deliberate obfuscation, and we talk about collective rights. Now, I don't think this is entirely an oxymoron, but I think that when you start to say this, the collective rights are more important than individual rights, you start to obscure the whole nature of rights as such. And on the question of race, I just have an amusing little anecdote. When I bought my car, unfortunately, I'm not one of those people who can afford to upgrade, so this is reaching back about a decade. And it was the design was an East Asian manufacturer, and on the form to buy it, it asked for race and put black, white, colored, or Indian. And I said, well, what if I'm Japanese or Korean? Particularly since this is the source of the vehicle. They didn't. They funny enough didn't respond to my email. And okay, so with that, let's go to Ivor Fechter. The civil liberty laws you propose. How do you foresee those being adopted, given the majoritarian rubber stamp nature of Parliament?
Yeah, thanks, Ivo. Yeah, that's an important one. So I'm taking it kind of as read that South African politics is in a kind of a period of change now, and that with any luck from next year or from 2026 or maybe even the election after that, we're not going to have this phenomenon anymore where one single party just calls the Speaker of Parliament and then whatever they want to happen happens. Sure, we'll still have dominant parties, but I think there's going to be a lot more horse trading and kind of negotiation, the type of thing, lobbying even, that you'd expect in a kind of a healthier democracy. With any luck, hopefully, this is what's going to start happening, and it's what I'm kind of assuming is going to start happening. So this is with that in mind. Currently, up to now, and the previous 3 decades of South African politics, these laws would not have even been able to be considered. But I think that's changing, and things like this can now maybe be placed on Parliament's agenda. And then considered. Of course, I think with the courts, it's a bit easier. Well, yeah, it depends who you ask, but I think judges probably have that greater capacity to sit down and consider a good argument and say, "Wow, okay, I'm convinced that this should be our new approach to how civil liberty is adjudicated in South Africa." Yes, the parliamentary interventions are a bit more difficult, but one hopes that the new political parties that are emerging and the kind of the old ones that are kind of gearing up to take a seat in national government would take some of these recommendations seriously. I must add that it's not an all or nothing. The recommendations I make are not all or nothing. You can take bits and pieces from them. They're kind of all kind of freestanding and can be adopted in various ways. So I've kind of made leeway in my recommendations for politics to kind of take its course.
Graham McIntosh remarks the U.S. Supreme Court's most recent decision also wipes away race as a criterion for judging a human being's worth. I don't know if you would like to respond to that or just take it as a comment.
I'll just briefly say that, yes, I saw that. I haven't read the judgment yet. I would say that it would be a problem if the principle applies to private universities, but that's to be seen. I think private entities should have the civil liberty to discriminate if they want. They can dig their own hole in that respect. Just funny, I got in big trouble on Twitter recently for Tuli Maronsela is very upset with that Supreme Court case judgment. And she said, well, race-based admissions to universities have good intentions, so therefore you must allow it. And I just made what I consider to be a very normal statement to say that, well, all bad laws, all oppressive laws fundamentally have good intentions, including apartheid laws also had good intentions. And of course, Twitter strung me up for even alluding to such a thing. So yeah, no, I'm very aware of that judgment, and I'm going to read it with some interest.
Okay, and Sarah, gone. You and I representatives of NGOs who are articulate, knowledgeable, and experienced, calling for the Constitution to be done away with because their desired outcomes aren't being achieved. They blame the Constitution, but should rather focus on government's failures, policies, and manipulation of the Constitution. To which I would just like to say, we've seen this coming from. We've seen this kind of narrative that goes back at least 15 years or so. There was a former cabinet minister who said that it was a fatal compromise tilted against the forces of change during the Fallers protests. This line became prominent. What's your response to this?
Yeah, so I don't want to get excessively academic, but I would say it kind of comes down to a misunderstanding of what constitutionalism is. A constitution isn't fundamentally there, or the law isn't there to make government's life easier to achieve whatever the good intention, the good reason is today or tomorrow or the day thereafter. A constitution at its base exists to provide a limiting framework for government and to ensure that the maximum possible amount of autonomy is granted to ordinary people in society to get on with their lives. A constitution is fundamentally based on that recognition that not everyone has to be a trooper in the agenda of the aristocracy. The people can have their own lives and pursue their own interests, and they do not have to ask for permission for that. So a constitution limits what the government may do in society, and it provides that kind of skeleton, or maybe even a straitjacket in which the government must operate. Now, when these people say that the constitution was because it didn't nationalize all land, or it didn't allow government to just seize property, and that it kind of allows people to express racist opinions and so on, therefore it must be done away with. Well, this is just a constitution being a good constitution. You know that a country has a good constitution when people are allowed to disagree very fundamentally with one another, to the extent, yes, of being bigots. You test the freedom of a society by seeing how well it treats its most despised and contemptible individuals. And in South Africa, that's probably going to include, unfortunately, our farmers, who are routinely accused of the most heinous types of infringements of human rights. And yeah, unfortunately or fortunately, a kind of a society does need secure property rights for food security and for really economic prosperity in general. And the Constitution, rightly, as any good constitution should, protects this against any kind of majoritarian passion or whim, or even minoritarian passions or whims, and recognizes that the individual has the right to tame nature around them, to take property honestly and legitimately, and own it and enjoy the fruits of that property. So it's kind of, when you see people criticizing the Constitution for doing these things, you know that in its text, at least, we have a pretty good Constitution. So I take that as a good thing. You never saw this in the Soviet Union, or you don't see it today in communist China, where people are like, oh, but the Constitution. No one cares, because the Constitution has no consequence in reality. Our Constitution still, thankfully, has some consequence in reality.
Well, if I can, if I can actually just pick up on a point there, I know that in East Germany, and I think in the Soviet Union as well, the Constitution actually specified that the Communist Party, the Socialist Unity Party, is the political expression of the working class and the leader of society. So actually, a lot of people don't understand about some of those former East Bloc countries. They weren't necessarily one-party states, but other parties had a sort of legal obligation to play second fiddle, and you would sort of have this election list where you could get a couple of people from the nominally liberal or nominally conservative or nominally it was usually a peasant party, but they all knew exactly that their role was to do what they were told. I think that if I can just probe a bit further here, how would you then respond to the argument that has been made very much in the kind of Asian values discourse, that you first need prosperity? You need a mighty interventionist state that can raise people's living standards, and then we can talk about the rule of law and if you. I think that for a lot of people living in less than perfect circumstances in South Africa, you look at developmental successes in China or South Korea or Taiwan, often under very authoritarian governments, and you can say, wow, okay, I'd trade free speech, I'd trade the right to assemble or vote in an election. In fact, Afrobarometer's polling shows that there's a lot of sympathy for that. So exactly. Your response?
Yeah, so this is something that does come up often. And look, I'm sympathetic. I understand where that sentiment comes from. And really, at some level, I'm willing to say that, yes, if we could deign it to be that I will now simply trade freedom of expression for 5 years, and then I'll have a house and a car and a nice fat bank account, and I'll get my freedom of expression back, then yeah, let's do it by all means. But that's not reality. That's simply not how it works. The idea of the benevolent dictatorship is we're able to mention those examples because there are so few of them. Usually, a dictatorship is very far from benevolent because the nature of dictatorship is you can't plan it. You can't say, okay, I'm writing a constitution, haha, for my dictator, and he must comply with it. Immediately, you don't have a dictatorship anymore. So you can't preload your dictatorship to say you must be a benevolent dictator and give us prosperity, and we're sacrificing our freedom to you for in exchange for that. That's simply not how it works. If you get a dictator, you're playing Russian roulette, and if you're lucky, you're going to get a benevolent dictator, and then things might be great. But more often than not, which is probably then kind of the opposite of Russian roulette to an extent, you are going to pull the trigger and you are going to blow your brains out. You are going to get the most vile scum that society can offer, who are going to filter to the top and become the leaders of your society. So that developmental kind of authoritarian statism is nice in theory, and it might have come out in East Asia due to various cultural factors and various historical forces. We simply do not have that in Africa. It does not exist. It is not here. We're not going to get it. Botswana may be the only example anywhere in Africa, and even then, I think Botswana probably has far more elements of liberal democracy than many people might like. So yes, I'm sympathetic to the notion, and if it were only so that we could say I am ordering kind of an Abraham Lincoln dictator for South Africa for the next 10 years, great stuff. But yeah, you can't plan that out. So let's rather go with the government in the straitjacket, and then society itself empowers itself because it can, and it will if allowed to. You don't need the government to drag you out of poverty or to drag you into prosperity. Society can really and does really do that for itself if the legal environment is sufficiently respectful of a free market and a free enterprise system.
Yeah, I think an interesting thing about Botswana, and I'm speaking under the possibility of correction, is that it has a basically liberal democratic political system, but it has very strong, deeply rooted, and sometimes quite authoritarian social structures. And that imposes a great deal of, let's say, order onto society. For better or worse. I see that Ivor Factor says, I've often toyed with the idea that if forced to choose, one should choose economic liberty before political liberty. Political liberty will then come with prosperity. Chile under Pinochet is a good example. Your response?
Yeah, I have my sympathies for Chile under Pinochet. I mean, obviously, as a liberal, there are many things that he did that I would certainly condemn in the strongest possible terms. But it can't be denied that he knew how to get the economy right because he listened to good advice and he got great advice. And today, Chile is I think the most prosperous country in South America, and they're trying to undo that with very silly ideas for their new constitution, which must be resisted. So yes, I'm sympathetic to that, and yeah, I think I kind of agree with Ivo there. You'll notice that in my report, I do not talk really about political liberty, which is effectively kind of democracy. I think that it might be that we can place some more limitations on democracy, and I'm saying this not in the way of like justifying dictatorship. I don't think these two things are opposites of each other. I think the opposite of dictatorship is constitutionalism. We need a lot more constitutionalism. But democracy kind of also has exhibited its own dictatorial elements. And I think in South Africa, we can see with things like the hate speech bill and expropriation that at least nominally, and I think IRR research shows that it is not necessarily true. But if you take like a superficial view, you might get the idea that, hey, the majority of South Africans want the hate speech bill. The majority of South Africans want the expropriation bill because there is hunger for land. And unfortunately, democracy does operate very superficially. So if I had a magic wand and said that, well, the government simply is not allowed to adopt things like the hate speech bill, and simply not allowed to adopt things like the expropriation bill, even if it has a clear and unambiguous democratic mandate to do so, or even minimum wage laws. The government simply may not. So that would be less democracy. Then I would wave that wand and I would say, yes, that democracy should be limited to that extent, so that democracy itself does not limit civil liberty. So to that extent, I agree with Ivo and the great liberal Friedrich Hayek. He wrote very widely about this, and he was described as an authoritarian liberal because he wasn't always a Democrat. And I think I'm with Hayek on this. I think the passions of democracy are often quite destructive. They're certainly preferable to giving some clown the power to rule the society at a whim. But I think the third way, what I have suggested, is constitutionalism. We must have a strictly limited government, and that means strictly limited in respect of one-person despotism, and also strictly limited in terms of unbridled democratic majoritarianism.
I think that what you're talking about is what number of people I think most prominently in its early iteration, Fareed Zakaria referred to as constitutional liberalism. He said that while there was a wave of democracy, you were not producing stable constitutional states. So your what you call the liberal democracies ran this gamut from like a minor offender in Argentina, where the president was ruling effectively by decree, through to Belarus, which was a distinctly more unpleasant variety of it. I see Genevieve Labuschagne says research conducted by Dr. Colette Schultz-Hartzenberg and colleagues has highlighted through Afrobarometer data that South Africa shows an instrumental belief in democracy as opposed to an intrinsic approach. Also, research conducted by Dr. Nicola Diaga shows that SA's belief in democracy has remained somewhat stable and high. There has been increasing support for non-democratic regime types, although South Africa. Could the country be heading that way?
Yeah, look, I'm not familiar with that research, but I think the instrumental belief in democracy is probably better than the intrinsic belief in democracy. I'm certainly a democratic instrumentalist. I think democracy should be used as an instrument to limit the government and to kind of avoid the very bloody wars that might follow when the governor has died and we now need to choose a successor. Democracy kind of gives an answer. You vote, and then you get the guy that everyone vote for, a nice and non-violent answer. So that's instrumental democracy in my view. The intrinsic principle of democracy, the idea that everyone must kind of have a vote in, I don't know, in everything or in important matters, I think that's a very, very dangerous idea. And I think that to the extent that we've played with that idea, it's not produced great results. The civil liberty kind of liberal approach that I support, which I hope South Africans kind of through their conduct also support, is that owners decide what they do with their property. And of course, courts can determine whether the ownership is legitimate or not. Was the property acquired in a violent way? Then of course the property must be given to its real owners, etc. So and then owners must be able to pay the wages that they agree with their employees should be paid, rather than that being voted on and the minimum wage act being adopted. So I think that it's probably good to have a high belief in the instrument of democracy rather than the intrinsic principle of democracy. But to the extent that this finds expression in South Africans voting for increasingly authoritarian political parties, which I don't think is necessarily the case anymore, but the fact that certain large political parties in South Africa are clearly authoritarian in their intent once they acquire power, that is a problem. That's a huge problem that we need to be careful of, because these political parties, I think, to a man, none of them have this idea of being the Asian tiger, adopting a kind of enforced capitalism where we like push the country forward through sheer grit and enterprise and innovation, and we force the country there. These political parties are almost exclusively strong men who only see self-enrichment and to the extent that they do have an ideology, it's communism, and we see famine and total destruction resulting from that. So yeah, it's kind of a mixed bag, and it's kind of a double-edged sword, and it's a very, very difficult tightrope to balance on. So yeah, I don't have an answer for whether we are heading in that way. We certainly could head in that way. South Africa, we like to think of ourselves as this miracle democracy, and as Jan Smith said, it's never the best that happens, and it's never the worst that happens in South Africa. It's always kind of the moderate middle way, and that's great. That's not guaranteed. It could get very, very bad. It could go very, very wrong in South Africa. We're not immune to it. So that's, again, why we need this vigilant and strong civil society to kind of keep government and the political system on the straight and narrow.
My sense of it is that we have a sort of discourse that invokes the Asian tigers and South Korean whatever, but very selectively. Oh well, because they had big strong states, and yeah, we'll follow that while using a sort of Soviet means of control. It's a dreadful case of being only willing to learn what confirms what you already believe. And Genevieve says, very insightful commentary and answer. High praise indeed. Are there any other questions from anyone? Well, I think that since no more questions are forthcoming, please, you will have seen the press release. Martin is available for media work, and he's one of those people who really does engage. So please do reach out to him. And thank you for joining us. And we look forward to seeing you all again here soon.
Thank you, everyone.